Hey, let's face it, our industry is under attack. While those of us in trucking view an accident, any accident, as a tragic event, there are those out there who look at it as an opportunity. Hit a truck, get a check. They look at your units as 18-wheel ATM machines. And this sense of litigation that everything results in a lawsuit continues, and we bleed suit by suit, case by case as we go along. But now we see a new phenomenon, something we couldn't even imagine a few years ago, where these verdicts have reached stratospheric levels, referring to them as nuclear verdicts, mega verdicts, verdicts of millions of dollars against companies by those who file suit. And what do? Well, they put them in the headlines, make sure everybody knows about them, makes them the new norm. They tout them on their web pages. Look, we've got to do something. What we're going to do today is to talk about what are the causes of these verdicts, what brings them about, and more importantly, what can we do about them? Now, you're not going to just listen to me for 45 minutes go on about this. I've brought in people who have recently studied and written about this topic. ATRI, the American Trucking Research Institute, recently did a study on nuclear verdicts. You can go to their webpage to find it, truckingresearch.org. But Rebecca Brewster, president and COO of ATRI, helps us today, and she shares with us the research they did. They went through data, looked at the numbers. What do the numbers show about how these are growing and what are the causes of them? They also went out and talked to people, plaintiff attorneys, defense attorneys, insurance people, as well as trucking people. What is their insight into the causes and the cures for these type of verdicts? Well, the next person we'll hear from will be Dr. Bill Kanaski. He is a behavioral psychologist with Courtroom Sciences, Inc. He comes from a different approach. He looks at it from the perspective of science. They've done a number of studies, and in the process of what they do, they have done focus group and mock juries. He tells us what they find from these research that they do in terms of what causes and what cures nuclear verdicts. He's recently written about it in DRI, an article that he's done. The last person from a legal perspective, in addition to myself, will be Bob Tyson, an attorney from Southern California. He recently wrote a book which is entitled, appropriate enough for this seminar, Nuclear Verdicts. And Bob tells us from what he has seen from the courtroom perspective, what he has written about and researched, how he sees it from a legal perspective. Okay, we're here today talking about nuclear verdicts, but how do you define it? What do you call one? I like the definition that Bob Tyson gives us. He puts it, well, I'll let Bob tell you.
Really, the way I look at it is where I used to look at it, where it kind of shocks the conscience, but the verdicts are so big now. Nothing's that shocking to jurors or to Americans. So it's more where the non-economic damages are so disproportionate to the economic damages. It's when you have an award that's $1 million in economic and $9 million in non-economic. And in my mind, that's a nuclear verdict.
Now you may ask, hey Doug, is it really that much of a problem? Is it really increasing? Short answer, yes. Comes from the ATRI study. They looked at the data, the details, the numbers, and this is what they found. They found that the average verdicts of greater than $1 million increased 967% from 2010 to 2018. They found a significant increase not just at the cases and verdicts over $1 million, but with cases over $10 million, mega verdicts. And before you think that this is just a function of increasing inflation and increasing health costs, the table shows you the verdicts are far exceeding both inflation and health medical care increases across that period of time. It is not a natural phenomenon based on economics. It is an unnatural phenomenon based upon the increase of verdicts and jury awards in these nuclear verdicts. Even if you haven't been at the epicenter of one of these nuclear verdicts, your company hasn't been hit directly by the impact, you have felt the seismic tremors that have gone out throughout the industry. Because these large verdicts are sending ripples out that are affecting and impacting the insurance rates of every company out there. Rebecca tells us about that.
Clearly, these nuclear verdicts are having an impact on motor carrier costs. It's certainly playing out in terms of insurance costs. And we have seen in other research we've done at ATRI in our operational costs of trucking, we've seen insurance costs per mile continue to rise. So what happens, Doug, is when those insurance costs go up, carriers have to, cannibalize that money from somewhere else. And so ultimately, I may decide to invest less in safety technology because have to pay the insurance bill. And so these nuclear verdicts are not necessarily raising the safety bar for us.
As you can see, these nuclear verdicts carry an impact far beyond just the company that gets hit directly. But it's easy to look at these only in terms of numbers, financially. But there is an impact far beyond that, and that was brought home to me a couple months ago when I'm reading an article in the Arkansas Trucking Association magazine about Randy Clifton. Randy grew up in trucking. From his childhood, his grandfather had a trucking company. In 2001, his father started a company, and when his father became ill in 2010, Randy took it over and ran it, doing well, doing successful. Well, one day, one of his tractors broke down. They were under load, and because they had to get the freight there, as you can appreciate, his brokerage operation brokered the load out to another company. The other company came and hooked up and started down the road, and you can see where this is headed. It got in an accident. Lawsuit happens. And Randy gets drug into that lawsuit. His companies get sucked into it. Well, I'll let Randy tell you what happened.
That was the thing. They actually voted that they felt that he was a subcontractor or independent contractor for us and that we should be held liable. And the jury awarded him $23 million.
Even before the verdict comes in, the mere fact that one of these lawsuits is looming can have a significant impact on the company and its finances.
Once the attorneys got a hold of it and started looking at it, they basically set up $1 million reserve, which is basically like they were planning on spending $1 million. So it looked like I had $1 million accident before we ever got to court, which caused our insurance to double. And so that hung out there every year, right. Every different, and we changed insurances, but they see that it's still in process. It's still out there.
And even after the verdict came down, while it was on appeal, Randy was able to survive, keep his company going, keeping it viable.
We still had our credit line. We were still able to operate. And so, we were able to go ahead and run basically 5 years past it, but it was still a struggle with high cost.
Well, ultimately, the verdict was reduced on appeal, but when the judgment was posted, now Randy has another problem.
They post this judgment. Well, once they posted it, they did that in January of this year. I didn't think too much about it, but we got a call from our bank, and the president called, and he was like, "We've got a problem. We see you've got a $6.5 million judgment posted against RCX." And he kind of knew about the lawsuit, and I kind of knew what was happening. But once that posted, the bank was very uncomfortable, so they froze our credit line. They basically said, "We're going to have to freeze your credit line, and we can't extend you any more credit until that judgment goes away."
Well, at this point, Randy thinks it's time to make a decision.
Me and my wife went to dinner, and we had one of those heart-to-heart discussions, and we're done. We fought it. We're tired of it. We're just going to have to shut it down. And so could have probably tried to get some outside financing, but it was such a struggle. It was just, you just kind of give up after that point. And then the reality that this can happen again. You build your whole life, your heart and soul into something, and it wasn't even our truck, which was frustrating enough to lose this. And then to know that anything can happen down the road and you start this process all over again. It just kind of takes the wind out of your sails.
Sure. And Randy's decision to close the company, that didn't just impact him and his family. It carried over to those who have worked for him and continued to work for him throughout this whole event.
We had 48 units running there at the end. And then we had 12 folks working in the office.
End of the day, what are Randy's takeaways?
This was such a unique case where, it wasn't our truck. It wasn't our driver. We weren't the ones that actually caused it. It was just our trailer. And when you start looking at how we got drug into something and took a loss over, just like logos and just those little things like that, you really have to be careful and guard yourself. And these things, it's really happening a lot in South Texas, New Orleans, Florida. It's just really gotten bad. And something really needs to be done because it's forcing a lot of small carriers out of business.
This is the real cost of nuclear verdicts. The people who get up every day, make the investment, take the risk, operate the companies, provide the jobs, and support their communities and those people who work for them, who move the loads and behind the scenes will dispatch them, maintain the units, and make sure it's done in a safe manner. This is why we have to protect and defend against these nuclear verdicts. Take action and move forward in doing so. Okay, we're having these nuclear verdicts and they're increasing every year. They're hitting companies with devastating impact, and they're sending tremors out throughout the industry. So what causes them? Well, let's start by looking at the data analysis by ATRI. They looked at the numbers, the statistics, and what they found was several things. First of all, they looked at the type of accidents. And they found that of all the accidents that give rise to a nuclear verdict, rollovers are by far the most likely to do so. From there, they looked at what type of resulting injuries are most prone to give rise to a nuclear verdict, and they found two types: spinal injuries and traumatic brain injuries. Makes sense, doesn't it? Those are the type that would seem to cause the most and the longest standing impact on an individual when presented to a jury. And what I found as I go around is that's something that the plaintiff's attorneys are picking up on. Because even cases where it is highly questionable if present or not, I'm finding plaintiff's attorneys trying to fashion cases, almost any case, into some type of head injury case as they go forward. Then ATRI took a look at, of the people involved in the accident, which is the most likely to give rise to a nuclear verdict, and what they find? Cases involving children. Those are the ones that are most likely to result in a large verdict, substantial verdict, as you can see by the chart there. Well, that tells us the numbers, some of the data in terms of what causes it. But those of us who go around the country and defend these cases know that there's another important factor that can play a role with regard to the potential for a nuclear verdict.
Well, like in real estate, location, location, location.
There you go.
Where you try that case makes a difference. And so this represents the percentage of verdicts that went to the plaintiff in the states where we had data in our litigation database. And so the darker the state, the higher the percentage of those verdicts went in favor of the plaintiff.
Well, in the industry, there are some places that are known to be worse than others. Places that have earned the title judicial hellholes. Well, what do we mean by that? How did they get that title? Well, and what is it that happens there that is worse than other places? Well, I spoke with Lauren Sheets-Jarrell. She's the Director and Counsel Civil Justice for ATRA, the American Tort Reform Association. She explains to us what do they look for and what is it that gives rise to a designation like that, gets the label judicial hellhole on a place.
These are places where judges are allowing either novel theories of liability to be pursued by the plaintiff's attorneys, or they're allowing liability expansion at rapid rates. We see a high rate of nuclear verdicts or excessive verdicts, in the hundreds of millions of dollars. And the plaintiff's bar is very familiar with these hellholes. They often have low barriers of entry. They have low standards for expert evidence. They allow plaintiffs from all over the country to file. So often venue reform is lacking. Personal jurisdiction decisions are very, again, low barriers. So the plaintiff's lawyers flock to these jurisdictions to file their lawsuits. They're known for their high awards and their plaintiff-friendly rulings.
Well, that's the judge's criteria. But for 2019, 2020, who are the big winners? Winners? Well, who's atop the list?
So this is the 2019-2020 list. We have several perennial hellholes on there. This was released last December and is what we have been focusing on for this year. Our new list will be released on December 8th. And we did have a few newcomers last year, and including a new number one judicial hellhole, which is, as you can see, the Philadelphia Court of Common Pleas.
Well, first, the Super Bowl. This gives new meaning to the word Philly special. Making those foam fingers on Broad Street, I'll tell you. But, TANY members, if you peek down the list a little bit, you saw someplace closer to home, New York City. Lauren tells you what they found and how it made the list.
New York City, you mentioned your interest in nuclear verdicts. We're really seeing an increase in nuclear verdicts in both New York City and in Georgia. those New York City is more of a recent thing that's going to be highlighted in this year's report. Georgia, the nuclear verdicts were a real reason that it appeared on this list for the first time in the state's history of while we've been releasing these hellholes for over 20 years. One thing we're seeing that is contributing to the rise in nuclear verdicts in New York City is improper anchoring, where plaintiffs' lawyers are improperly suggesting numbers and dollar amounts that the jury should award. And as a result, that's the sort of starting point for the jurors when they're deliberating. And New York has always had sort of a de facto cap of $10 million for pain and suffering. Since there's been this increase in improper anchoring, I believe 90% of verdicts have been double that amount. There was a recent study pointing to that and showing that data. So that's a real concern there. And again, in Georgia.
All right, the type of accident, who gets injured, and where the suit's brought. Key factors in general in terms of what can give rise to a nuclear verdict. But within each case, there can be one detonator, something that sets it off. Bill Kanaski, the behavioral psychologist, he tells us what he sees as being the key factor for potentially triggering a nuclear verdict.
And number one on that list, and it's a reason for number one, because it's by far the number one predictor of not just verdicts, but damages, is the quality of the witness testimony from the defendant.
Witness, it's not just their testimony. What they say or how they present it can taint your entire case.
Problem witnesses for defendants really seal the deal very quickly on liability. And then we start talking about nuclear verdicts, the more dislikable these people are, and the lack of trust, the lack of believability, some sense of sliminess even perhaps. This is what gets juries really out of control with those dollar figures. And so that's really the top factor pushing this, which, by the way, highly preventable and highly controllable.
And like Bill says, it is controllable and preventable, but you got to do something about it. Early on in the case, what we want to do is identify who's going to be the key witness in the case. Is it going to be the driver? Yeah, usually. Safety director? Often. And as the attorney, I rely on you to give me some background. What are the people like? Are they comfortable talking to people, a little shy, taciturn? What can we do? And I'll sit down and talk to them, get my own feel. And then what we'll do is get together and look at how can we help them to present what they have to say in a way that is believable and credible, and their own emotions or their own discomfort doesn't give the wrong impression to somebody. But the key thing is we need to do it early. If they need more than just you and I sitting down and talking to them, then let's get a specialist in, people who prepare people for jury presentations, for deposition presentations. But that's the other key thing. You've got to do it before the deposition. Because in today's world, most of them are videotaped and all of them are taken down in transcript form. They're locked in. After the deposition is usually too late. And if you do try to change something between the deposition and the trial, that often can even be worse because it looks like backfill at that point. You got to identify it early, work with the person so that they're comfortable, can tell their story, can put it out there, and do it before the deposition. That's the key thing. Bob Tyson tells us why that preparation is even more crucial when it comes to nuclear verdicts.
There is one main driver, and everyone kind of needs to understand this, that nuclear verdicts in the last 10 to 15 years almost never happen unless a jury is angry. That's a big change. Nuclear verdicts in the last 10 to 15 years, the focus has been on getting the jury angry. So anger is the number one driver, the number one factor of any runaway jury verdict.
So anger is the basis, the foundation for a nuclear verdict. Well, what does that have to do with your witnesses?
And it has to be done before deposition because remember, they've changed the way they try lawsuits. They're not focused on their client, they're focused on our clients. So we need to address that. You, the client, need to be challenging your defense lawyers like, hey, what kind of witness impression do you think my guy's going to make?
Witnesses have always been a key part of trials, litigation. But in today's world, we have a new element. We live in a YouTube society. I've had cases where the accident has been captured from a surveillance camera on a nearby warehouse. I've even had one that a pedestrian accident was captured by a passing Uber driver in downtown Manhattan. It is something that we have to be aware of, prepared for, and realize the impact that it has on the jury. Bill Kanaski, the behavioral psychologist, tells us his impressions, what he's found scientifically, in terms of what impact that has.
Because when jurors see that stuff, particularly in the form, especially now in 2020, electronic communication, pictures, videos, this is stuff the jury cannot unsee. Mm-hmm. And so I think it's very important that these cases get properly assessed and worked up initially to really position them for settlement. Because if you get into a courtroom, the jury will never forgive you for some of this stuff.
The importance of video isn't just a piece of evidence. It arises from the importance that video has and has become in today's society, in our culture.
On the news, and the only thing I see is video, trying to get voters upset. Which, by the way, who are the voters? Oh, they're your jurors. They're the same damn people. And so anything that has visual stimuli that is controversial, negative, shocking, these are the things. You talk about nuclear verdict. I don't even know what the word above nuclear is. Thermonuclear, I don't know. But I think that's where you see some kind of even crazier than we've seen, is where you have these cases that have video/audio of very bad things happening, which really drives a lot of emotion. That's what you see. And politics is driving this right now, but so is the plaintiff's bar, and it works on both ends.
Well, we've talked about the problem that we have, the increasing number of nuclear verdicts. We've talked about the causes of them. So what do we do? Well, first and foremost, make sure you've covered the fundamentals. Make sure that you are ready for any accident response plan, that you know who is going to respond for you and how you're going to respond. Look, if you have any questions or want to help, I've got accident response plan templates made up on Word documents for taking witness information, photographs to take, what documents to preserve. Shoot me an email. I'll be glad to send them to you. They're free, as well as videos to help train drivers as to what should be done after the accident and how to respond. Again, let me know. It's free information. Well, the next thing you want to do is when that accident happens, act. Get out there. We can lament the fate that we have based upon those billboard attorneys. But we have an advantage that none of them have. We know about that accident before any of them. We have the advantage of immediacy. And if we don't act immediately, and if we're not prepared to do so, we have squandered our greatest asset. Do the fundamentals. Once you've done that, once you've looked at that accident, then do an analysis. Is this the type of accident that the studies, that the information, that the factors show could lead to a nuclear verdict?
Yeah, first and foremost, do that risk analysis before you go into court. Take that quantitative data that we've accumulated in this database and analyzed in the database, and really understand, was there something operationally, safety practice, driver hiring, that we could have done differently to avoid this crash? Know what you're going into before you get there.
Look, the early assessment is vital. Take a look at it early on and make your decision, or at least know what you're faced with as you're going forward through this litigation. Do a proper and thorough analysis.
So another reason why nuclear verdicts happen is really a misassessment, bad assessment choices early, and a lot of hunches about what a case is actually worth, rather than putting the time, energy, and yes, money into jury science to figure out what the case is actually worth.
Often in a significant case, we'll go to a focus group or a mock jury, get a feel for what the case is about, the issues, the value, etc. But as Bill points out, if you invest that money doing so early, you can use that to your benefit in trying to get that case resolved before it starts to get momentum.
Well, we have many clients that will enter a mediation with our report, going to the mediator saying, hey, we hired people with PhDs in behavioral science. Here's the sample that they recruited. Here's what we showed them. Here are the results, meaning this is roughly a $5 to $8 million case. It's not the $55 million case that they're demanding. And we have scientific proof. And that has worked very, very often.
All right, we've analyzed the case. We tried to get it settled. We haven't been able to do it. What do we do now? Well, as we proceed through in litigation and ultimately the trial, one of the things that we need to do to keep in mind that the defense too often fails to do is to humanize our side of the case. I mean, this is a human being, a driver. This is a company that serves its community and provides jobs. We need to tell our story, to get it out there, to let the jury know that this is a person and people on our side of the case, just as it is on the plaintiff's side of the case.
Well, again, and this goes to our point earlier about humanizing, that's a noticeable difference. The defense side recognized in themselves, but the plaintiffs also pointed this out, that often the defense will follow on logical arguments. You know, this is how mechanically a truck operates. This is, you know, brake stopping distance, whatever the case may be. Whereas on the plaintiff side, they often will appeal to emotion, which appeals to all of us. And so, for instance, if there's a crash that involves children, they'll bring in a sibling and put them on the stand and talk about, you know, my brother's in a wheelchair now. So it really appeals to the jury, to their emotional side. And we need to recognize and do a better job of doing that on the defense side. So things like saying, you know, this truck driver has been a little league coach for 30 years in your community. Everybody knows him. That type of humanizing of the defense side is needed.
And it's not just a matter of the individuals, it's also the company. To humanize it to the jury as well. Bring home the fact that this isn't just a cold institution, but it is a business of people.
So I don't care how big it is. I don't care if it's a big governmental entity. You need to tell a human story. There has to be a face or multiple faces to the client, and waiting for trial to prepare them is way too late.
Part of preparing his book, Bob Tyson read the closing arguments of hundreds of nuclear verdict cases. And when he did it, he found one thing consistent throughout every one of them.
And there's a pattern. They all fit a pattern. And that's where the book comes in response to. And one of the patterns is when you're done reading the closing arguments, you know, and the trial went for a month, 2 months, however long it went. When you're done reading the closing, you have a really good feeling for who that plaintiff is. Like, you know that feeling. They do a recap of where they were born and what their family life was like. And this could be like a 50-year-old woman, and you know that she played sports when she was younger, and she was a strong girl and became a mature, go-getter woman. And then on the defense, almost bar none, when you're done reading the closing argument in a nuclear verdict, you know nothing about the defendant. Nothing, zero.
You know, in the years that I have been representing truck drivers and trucking companies, I've met great people. You know, I meet them in my involvement with state associations. I'm on the board of Pennsylvania, and through attending the truck driving championships, both state and nationals. You know, these are real people, real families. They drive on the road to get home safely so their families and others can be safe as well. Companies that give jobs, people who have done a lot for their community. That's the story that we need to get out in these cases, to tell not just what the ECM says, but who the people are. And, you know, having been seen in what we have done, and particularly you at TANY have done to keep your state and our country going during this time of pandemic, hopefully that carries over with what the juries see and how they feel about our industry, things that we have known for years that got more emphasis as we met the needs and were the lifeline of America.
If there's a silver lining to come out of the pandemic, I think this is one of those. both sides said that when when a verdict goes in favor of the defense, it is often because the jury understands how critical the trucking industry is, that particular trucking fleet is to their community, and how that truck driver is a member of their community, really humanizing the truck driver and what they do. And certainly, as we've seen in COVID-19, with truck drivers being classified as essential workers and everyone really starting to connect the dots that, if my store shelves are running bare, I need stuff, it's going to come on a truck. And so we need to understand and respect those truck drivers. And we've really seen that, rising of the stature of professional drivers as a result of the pandemic. Those of us in the industry have always felt that way, but to see the general public understand that, I think, is going to make that third bullet point a little easier going into court now, because if the jury understands how trucking impacts their lives, they're less likely to say, oh, that's just big corporate business, let's stick it to them.
And as we spoke earlier, we need to bring that story out about the company, who it is, what it does for its employees, the community, and as a business as a whole.
An important piece going in, if you're going to go take this to trial, helping the jury understand this is a 3-generation business that's been supporting this community for years, been providing jobs for this community, good paying jobs for this community, tapping into that. Look what happened during the pandemic. These were the people who kept your store shelves stocked. I mean, it's just, I think there's a great opportunity for us, but helping the jury understand how valuable these men and women are who drive trucks. They're not out there to harm anyone. They want to get home at the end of the day as well.
And while it is important to humanize the driver and the company, to make sure that their story gets told, one thing we have to keep in mind throughout this entire process is that it's a fight. Someone's coming after you and your company. Someone's out to eat your lunch. And we have to fight back just as hard, no, harder, in order to protect you and your company. This isn't a situation where you go through the case, you do the machinations, exchange the discovery, do the depositions, we're going to settle it. Maybe, but you fight every inch of the way as if it's going to go the whole way through trial, because that's how you get the best results. Even if you settle, you're going to get the best settlement if you have taken this as a case that is going to go the whole way through trial and you're fighting it every inch of the way and preparing for it to do so.
No, it's a fight for justice. It is a fight. Plaintiff's bar knows that, and the defense lawyer knows, well, I'm going to trial today, and there's a lot of good defense lawyers, but I think a lot of people get shocked. It's like Mike Tyson said, no relation. Everyone's got a plan until they get punched in the mouth.
Yeah.
And plaintiff's lawyers come out and they punch you in the mouth. So get ready. Figure out what's going to make the jury angry. Get ready. Diffuse it, right? Block that punch, right? Be ready for it. Diffuse it, and then punch him back. Punch him harder than he was going to punch you.
And what about those instances in which we don't have a basis to sue, or the plaintiff has sued first in a less than friendly jurisdiction? Well, I recently spoke to Kurt Ruhe, Vice President General Counsel of Creek Carrier Corporation and a thought leader in transportation litigation. Here's Kurt's thoughts in terms of challenging that jurisdiction.
So the kind of takeaways I have are motor carriers shouldn't overlook jurisdiction as a tool to fight when jurisdiction in a state doesn't make sense. That kind of gut check reality that so many attorneys have that, oh, do you drive trucks in this area? Do you have a terminal in this area? Well, yeah, we have trucks and terminals in your state. Okay, well then you're just stuck. That mindset isn't necessarily the law in 2020. And so I think we can all benefit from taking a little bit closer look at that question, and we've kind of set out that framework of when to do it. If the accident doesn't take place where the case is brought, and your driver's not from there, your company's not from there, it's really worth taking another look at jurisdiction. And Doug, the way I kind of put it, to make it real simple, is my former colleague Dave Brown had a handful of truisms he'd like to say, and one of them was, if it doesn't make sense, it doesn't make sense. I think you should look at jurisdiction that way. If you're looking at a scenario where you're saying, hey, suit here doesn't make sense, then it probably doesn't make sense. Go to the case law and see if you can make an argument, because it might be worth trying.
We can push back against the geographical challenges that give rise to nuclear verdicts. When warranted, we sue them first. If we are sued in a location where there's no jurisdiction, we challenge it based upon the latest Supreme Court rulings. Another matter that can give rise to nuclear verdicts and can drive the cost of any litigation or medical cost. These medical costs, the ATRI study notes, are based upon increases in medical technology, medical developments, malpractice costs, other things that increase their amounts. And one of the issues that gives rise is that there is no universally accepted means of what to measure or how to measure the cost between plaintiffs and defendants in these matters. What we see in litigation is often where the plaintiffs will use medical costs as a floor, use that as the basis of their evaluation of the case and claim of what the damages are. The evidence of which they base those is usually a doctor who anecdotally says, yeah, those appear to be the reasonable and customary charges for this area for that. Or in larger cases where they're projecting future medical care and future medical costs into the future, they use a life care planner who will develop those costs, often by looking at price sheets, looking on the internet, or just making some phone calls. Well, we can push back against that. Push back with evidence that directly and competently challenges medical cost. We go back against them using a medical healthcare economist, somebody who actually does that for a living, works in the area, and bases their findings on the data.
I'm John Schneider. I'm a health economist, which means I research pretty much all aspects of the health industry. Health economists use data to build models and calculate the value of medical products and services. I have a small consulting company that provides a variety of economic analyses to pharmaceutical companies, medical device companies, and businesses involved in health-related litigation.
That's Dr. Schneider, a health economist. And Dr. Schneider has helped me in cases and in trials in terms of analyzing the medical bills, not just for what they claim to be, but for what they really are. Because medical bills, as we all know, are like sticker prices on cars. There's a price, and then there's a price. Some of you might remember a time when an auto manufacturer said, look, we're just going to have a price non-negotiable on the sticker. I think that was Saturn. How did that work out for them? Well, listen, Dr. Schneider tells you what he does, how he does it, in terms of the application of his field to the medical bill analysis.
The litigation work we do fits well within the field of health economics because a big part of a health economist's daily activities is to figure out the fair market value of healthcare products and services. Billing data, which is the most commonly available data, doesn't reflect fair market value or reasonable value, so we rely on well-developed methods to calculate reasonable value of all of our work, whether it's for a pharmaceutical company or a business involved in litigation.
That's a key point in these cases, and particularly a trial. What Dr. Schneider does is primarily do economic work for the health industry. But in the litigation standpoint, he applies those same principles to the litigation cases. Well, he'll tell you now how he gets to those numbers and what he uses to determine what is the true fair cost of medical treatment in a particular case.
Calculating fair market or reasonable value varies depending on the type of medical expense. For outpatient expenses, such as doctor visits and prescription drugs, we rely on commonly used benchmarking data specific to the geographic area in question. For hospital expenses, we rely on patients' actual bills, but we remove the high markups from these amounts, which can sometimes be as much as 300%. We use financial data from the hospital where the patient was treated. We then add back in a market-based profit margin. There are some other specific calculations that may be necessary, but those are the main approaches. The result are amounts that are much more reflective of fair market or reasonable value.
So as you can see, in contrast to a doctor giving his anecdotal opinion as to, yeah, these costs are reasonable and customary for the area, Dr. Schneider presents evidence as to what the data shows for that particular area.
The main problem that we're trying to address is this. In most cases, past medical expenses are based on charges, which nobody pays and don't reflect reasonable value. Future medical expenses are typically even further from reasonable value, based on rough estimates from life care planners or calls to medical facilities, where the same billing rates are read from a fee schedule. But these rates don't represent fair market value. Nobody pays these rates. In economics, fair market value or reasonable value is based on the prices at which buyers and sellers transact. Starbucks can offer a cup of coffee for $100, but nobody would buy it. Is that coffee still worth $100 if nobody will pay that much for it?
Common sense, right? Well, what's the problem with common sense? It's just not that common. Look, that logic and that data-based analysis has been successful in both negotiating cases, mediation or pretrial discussions, as well as in trial themselves when we present it to a jury and say, here is solid evidence of what those medical bills are. Those are some of the ways that we can come back and attack and take the offensive against these nuclear verdict potential cases. Well, another way that Bob Tyson says that from the insurance, the adjuster side, that this can be, and many of these procedures can be institutionalized by changing or even just adding to what they do to evaluate the status of a case and working with their attorney in addressing these problems.
So to all our clients out there, I would say if you require pre-trial reports, if that's something you require, I wouldn't change them. You have them, you want to know about the venue, you want to know about the judge, you want to know about the experts. That's all good. But I would add a couple of things. I would add things that will stop nuclear verdicts. So if I was king for the day, I would add several things. I would say, I would put a heading. What's going to get a jury angry about this case? How will you diffuse anger? And then I would say, what are you going to accept responsibility for? What number are you going to give the jury? How are you going to personalize the defendant / insured? How are you going to argue pain and suffering? There's 6 things I just came up with off the top of the head. Do everything else you're going to do.
Yeah.
But now you've got your defense lawyer thinking like a plaintiff's lawyer. And if he or she can execute on that,
right,
you're going to be far and far away, much better place than you were before.
The information we gave you today is insightful, helpful, informative. In one other thing, one of the criticisms of the various studies, the people that we heard from today, that they have developed in what they've researched, is that while the plaintiff attorneys share their knowledge, their strategies, what they have found is helpful, that it's not done enough on the defense side by the defense attorneys. They keep it to themselves. They don't want to share it for fear of, losing clients, or whatever it is. Let's change that. I've set up a YouTube channel. I've set up a podcast. What I'm looking to do is to share this information and do a weekly newsletter to help to get the information, get the word out. Links to those podcasts and to that YouTube. If you're interested and you'd like it, shoot me an email. Let me know. Be glad to get it to you. Be glad to get you involved. And guess what? It's free. Listen, take care. Be safe. Have a good one.